Sri Ram's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to Sri Ram's IAS, welcome to this concept class. So today we are taking up a very important concept class which is related to Article 21 of the Constitution of India. Article 21 of the Constitution of India relates with right to life and personal liberty. We all know about what life is, but what do you mean by liberty? Now that is a question we are going to delve into. And this particular concept under article number 12 has evolved over decades in India, constitutionally speaking. From A.K. Gopalan case to Maneka Gandhi case, and from Maneka Gandhi case further to K. Puttaswamy case, this has evolved a lot and it has seen many facets. So what do you understand by liberty? Now when I say liberty, it is one of the most important requirement for human life, isn't it? People fight for their liberty. The person who is not liberal is also not happy. Nobody wants to live in chains. There have been revolutions for liberty. India has fought a freedom struggle for liberty from the foreign yoke. Similarly, think about a situation where you are being detained by a lawful authority or an illegal authority. Your liberty is compromised. What happens? Are you happy? Will you be happy? That does not happen. Human beings seek economic liberty. They seek social liberty. They seek political liberty. Liberty is one of the cornerstone for human development and human happiness. Without liberty, the life is only an animal existence. And when Supreme Court says right to life and personal liberty, so life is not only animal existence. It has to be a dignified life. What is dignity? That's another question. What is dignity? It is the inherent right to be treated of some value, to be considered, to be treated with respect. Just because you are born as a human being, you have some human rights. Those are also enshrined in our constitution as fundamental rights. And one of them is article number 21, right to life and personal liberty. A very, very important right. Now, what happened in A.K. Gopalan case? What happened in Maneka Gandhi case? What happened in Puttaswamy case? That is something which we have to see. We have to see the journey of article number 21 and how it has evolved and became the fountainhead of myriads of fundamental rights in India. Now, it is a mammoth article which takes into its consideration almost all the rights. All the rights which are given in the Constitution of India can be linked to article number 21. It is such an important right. And how it has become through the interpretations made by Supreme Court over the period of time. In A.K. Gopalan case, this particular article number 21 was limited. The interpretation was very limited. The text of this article read, as no person shall be deprived of life and personal liberty except according to procedure established by law. It was talking only about the procedure. A.K. Gopalan, who was a leader, was taken into custody on preventive detention by the state. He challenged his preventive detention in the court, saying that it is hurting its article 21. But the court narrowly interpreted article 21 and said, upheld it, A.K. Gopalan's preventive detention, and said that if the procedure established by law is followed, then the detention cannot be questioned. That the court is not going to inquire into the justness, fairness, and non-arbitrariness of the legislation. It is not going to consider the due process. It is not going to consider the substantive part of the legislation. What it is going to consider? Only whether the procedure has been followed or not. To understand this better with an example, if a law has been passed by the parliament, for example, if you steal 10 rupees, you will be sent to jail for 10 years. Is it fair? Is it just? I don't think it is. Is it arbitrary? Yes, it is arbitrary. It violates the principle of proportionality. For a murder, you can send somebody for a 10 year of imprisonment or for a life imprisonment, or for that matter also, if the murder is one of the kind, rarest of the rare case, you can also put the person on gallows. You can put him on life sentence. But just to steal 10 rupees, if you send somebody to jail for 10 years, this is not just practice. This is not a fair practice. This is not an arbitrary practice. Now, what will happen in today's world if such a thing happens? If this particular law has passed by the parliament, the constitutionality of this law would be checked by the judiciary. Judiciary is going to see the substantiveness, what is also written in the act, that will be checked. That is the whole point of constitutionality, isn't it? But in 1950s, during the commencement and just after the commencement of the constitution, the article number 21 was very narrowly interpreted, only limiting to the executive actions. Executive actions, if executive takes some action which is not according to the procedure established by law, then article 21 can be called into action. But if it does anything which relates with the justness, fairness and the non-arbitrariness of the law, that was not considered under the jurisdiction of article number 21. Hence we can say it was a very, very limited interpretation of article number 21. That is what has happened in A.K. Gopalan case, and this position continued for a very long time until the next case came up. That was the case of Maneka Gandhi in 1978, when she was stopped to visit a foreign country. She was arrested on the airport and her passport was impounded. She approached the court by saying that this is the violation of article 21 of her life and personal liberty. Now Supreme Court has interpreted this article in a very wide sense. Supreme Court said that it is the right of a person to move freely within the country under article number 19, but it is also the right of a person to move abroad or to visit some foreign country wherever he wants or she wants to visit. At the same time, the court said that it is not only the procedure established by law which has to be seen, but also the due process of law which needs to be checked under article 21. That means article 21 becomes the basis to check the just, fair and non-arbitrary nature of a particular legislation made by the Parliament of India. If a law is passed by the Parliament of India, it has to pass the reasonableness of article number 14 and article number 19 as well. That simply means Supreme Court has interpreted article number 21 so widely that it takes into consideration article 14 and article 19 as well. If there is a violation of article number 14, it is an automatic violation of article 21. If it is a violation of article number 19, it is an automatic violation of article number 21. A golden triangle has been formed by the Supreme Court through its interpretation of article number 21 in the Maneka Gandhi case. And after this case, this article had took mammoth proportion. It is so wide today that almost all the articles can be linked to it, all the fundamental rights can be linked to it, and there are so many aspects of human life which can be linked to article number 21. Moving on to the next slide, see here, these are some of the rights. Right to privacy, K. Puttaswamy case, 2017. What happened here? What do you understand by privacy? Start from your phone number. What if I share your phone number on internet to everybody? Is it a breach of your privacy? Yes. What if government surveillances are happening over your finances, over where you go, where you visit, whom you meet? Is it the breach of your privacy? Yes, it is. So privacy is a very, very wide concept. Whom you want to marry, whom you want to date, whom you want to meet, whom you don't want to meet. That is all considered under privacy. Too many of the state action has been taken out by the Supreme Court on the basis of privacy, that it is against the concept of right to privacy of a person. It is contravening the right to privacy of a person. So privacy is a very mammoth concept, and this right to privacy has been included under article number 21 by the interpretation of the Supreme Court, that Article 21 now also contains right to privacy. This is a very, very important sort of interpretation. It's a very, very important judgment of the Supreme Court. Right to dignity in death. This particular thing concerns about passive euthanasia. That if a person is suffering from an illness which is not going to end, and the suffering is very wide, the suffering is permanent, then if a person makes a will that the life support has to be withdrawn and should be withdrawn when there is no point of recovery, where the doctor think that the person cannot recover and the suffering becomes unnecessary, then that will made by the person to withdraw the life support has to be respected. The Supreme Court has interpreted right to dignity in death. There is right to life which is given under Article 21. At the same time, right to have a dignified death is also given under Article 21 of the Constitution of India. Now that is the mammoth nature it has taken. So many of the rights are covered into Article number 21. Decriminalization of same-sex relation, Section 377 of IPC. It has given rights to LGBTQ community to become parents. Their relationship, the sexual orientation of the person, none of them will be decriminalized. This is a very old law which was there, a very old provision which was there before the commencement of the Constitution. It was still running. It was made by the Britishers, but Britishers have taken out this from their legal and government procedures a long time back, but India was continuing with it. Supreme Court jumped in, the Delhi High Court jumped in and decriminalized Section 377 of IPC. Again, this interpretation is also linked with Article 21 of the Constitution. The right of the LGBTQ community, the right of a person to have his or her own sexual orientation, the right of a third gender was also recognized under Article 21. It has become a fundamental right now. This is very important. It is also linked with right to privacy, by the way. It is the private affair of a person. I hope you are getting this. Another one, see this one. Reproductive autonomy and bodily integrity. Right was given to a woman to abort a baby. Does not matter whether the person is married or not. Earlier, according to the Indian law, if the woman is not married and the pregnancy goes beyond 22 weeks, she was not allowed to abort the child. But that freedom was given to the women, considering this under reproductive autonomy and bodily integrity of women. Also one of the aspect of right to life and personal liberty under Article 21. Again, another interpretation which is enriching Article number 21 and giving it its mammoth form it is in now. Freedom of personal choice, Hadia case as it is known. Right to marry of a person. It is a very personal choice of a person. It's a very private choice of a person. Whom you want to marry. Do you have to change your religion to marry somebody? And if you want to do that, you're free to do that. That is what has been proved through this case, where a person has changed her religion to marry another person. It's a very important case where the Supreme Court is trying to prove that the state must not interfere in the decision making about a personal issue of a human being. That the person has to take a decision related with his or her marriage. It should be left onto them, and the state must not interfere in that because of whatever reason. So again, it is a wider interpretation of Article number 21. The Article number 21 has become so big that it takes everything inside itself, all kind of rights, are now the part of article number 21, became a fountainhead of myriads of rights. Environmental and climate change. So, in one of the judgment of the Supreme Court in 2023, Supreme Court declared that right to have clean air, clean water, right against climate change is also the part of article number 21. This has also been interpreted by Supreme Court to be part of life and liberty. Again, do not forget the concept that life cannot be animal life. It has to be dignified life. And for dignified life, the impact which climate change have has to be nullified. The impact which unclean air or polluted water have on the health of the human being has to be nullified. And for that reason, article number 21 has been interpreted to include right against climate change. This is a very important judgment of the Supreme Court, which again expands the jurisdiction of article number 21. There are other important judgments as well, we are going to see in the next slide. Right to internet. This was a judgment of 2019. Right to be forgotten. Think about a person who was convicted of a crime. The person went to the jail and came out serving whatever number of years he was sent to jail for. And when he comes out of the jail, he is not allowed to have a job because there is some kind of thinking in the society that he may commit the crime again. But he has already being punished for his crime. The person has already completed the punishment and then he is out. So his past is carried on into his present and he is suffering because of his past in his present also. And there is where the right to be forgotten comes in. That all the news which was there, and it's a great debate. People say it in a wider way, if you see, that helps to keep the society more secure. But at the same time, if you're looking at the individual, what is the meaning of reformative criminal justice system? If you have a reformist criminal justice system, a person needs to be reformed, should be reformed, is considered to be reformed after the person completes the punishment. And after the person has completed the punishment, if the person has been punished again by society, not by law but by the society, by not giving the person a job, not giving him the place to live, then it's a perpetual punishment. And that is where right to be forgotten comes in, that all the information the person has related with his past on internet can be removed. If a person desires to apply this right, then the government, the news channels, the news agencies, the platforms such as Facebook and Instagram and everything should remove all the information related to one person about his past. It's a very, very important right which is now also included under the definition of right to life and personal liberty under Article 21 of the Constitution. Right against climate change, we have already seen this, and end of manual scavenging, again a very important right to uphold Article number 21 of the Constitution, also linked to Article 21 of the Constitution, because most of the manual scavenging today also is done by people of marginalized sections. Okay, so Article number 21 has become the hero of all the fundamental rights in the country. So what is the philosophy and the significance? If you see, Article 21 embodies human dignity. We have already discussed what dignity is all about. It is the inherent right to be respected, to be valued, to be considered. Okay, just because you are born as a human being, you should be respected as a human being. And human being needs respect, needs value. His or her point of view has to be considered for him or her to grow. Autonomy. So Article 21 embodies human dignity, autonomy and justice. Foundation for many socio-economic and digital rights. Again, with the emergence of the digital era, Article number 21 has become so mammoth that it includes inside it right to internet, right to be forgotten, which is all related to digital rights of a person. Judicial activism has made it dynamic and living right. So as we have already discussed that it wasn't a very big right in 1950s. It was only limited to procedures established by law. It was only limited to be against the executive action, and it has nothing to do with justness, fairness and the non-arbitrariness of law. It does not concerns itself with the substantive nature of law, but was only concerning itself to the procedural aspect. But with courts interpretation, with judicial activism of the court, and especially after the watershed event of the Menaka Gandhi case in 1978, article number 21 has been interpreted very, very widely. Includes inside it the due process of law, that is very important. The substance of a law, whether that is correct or not. The reasonableness of article number 14, article number 19 is also considered under article number 21. So there is a golden triangle. Whether a particular statute or a provision made by the parliament is standing the reasonableness of article number 14 or not, is standing the reasonableness of article number 19 or not. And if it is not, then it is not standing the reasonableness of article number 21 as well. So in a way we can say article number 21 also covers right to equality and right to freedom. Okay, I hope you understood this article, this concept very dearly. It is very important not only for your examination, it is also important for your life to understand what article 21 is all about. So students, thank you very much for joining me in this video. I'll definitely come up with the next very important concept in the next class. Thank you very much and have a nice day. Jai Hind.